Hello, I am Seth Kim, and I am an associate at Birch, Stewart, Kolasch, and Birch. In a November 21, 2016 decision, the Federal Circuit in Unwired Planet, LLC versus Google Inc. held that the Patent Trial and Appeal Board, PTAB, relied on an incorrect definition of a covered business method patent in instituting a covered business method review to challenge the validity of Unwired Planet's patent covering a method for restricting access to our wireless devices' location information. A covered business method review is one of the post-grant reviews that were instituted by the America Invents Act, AIA, and allows challenging of the validity of a patent. It is an administrative trial conducted by the PTAB and is available until September 15, 2020, which is 8 years after implementation of the AIA. CBM is available at any time other post-grant reviews are not available, and if the PTA determines that the patent is a covered business method patent. The CBM review is an adversarial proceeding where the accused infringer can participate after filing a request for the CBM review and allows validity challenges on any ground that is a condition for patentability. AIA Section 18 provides the statutory basis for the CBM, and there are two prongs of the CBM determination according to the statute. The first prong is the financial product or services prong that states that a CBM patent is one that claims a method or corresponding apparatus for performing data processing or other operations used in the practice, administration, or management of a financial product or service. The second prong is the technological invention exception prong that states that CBM review does not include patents for technological inventions. The PTAB has previously broadly interpreted the financial product or services prong as including patents that relate to activities that are financial in nature, incidental to a financial activity, or complementary to a financial activity. Meanwhile, the PTAB has previously narrowly interpreted the technological invention exception prong to patents in which the claimed subject matter as a whole recites a technological feature that is novel and unobvious over the prior art, and solves a technical problem using a technical solution. With this background, we turn to the case at hand, Unwired Planet, LLC v. Google Inc. Unwired Planet owns U.S. patent number 7203752, which is directed to restricting access to a wireless device's location information. A user of such a wireless device may specify privacy preferences that determine whether client applications are allowed to access their device's location information. A server is used as a clearinghouse for requests of the location information. The Federal Circuit found that the PTAB's definition of the CBM as covering activities that are financial in nature, incidental to a financial activity, or complementary to a financial activity was not proper and contrary to the AIA definition of CBM as a patent that claims a method or corresponding apparatus for performing data processing or other operation used in the practice, administration, or management of a financial product or service. When the PTAB took such disclosure and found it to be incidental or complementary to potential sales resulting from advertising, the Federal Circuit found the PTAB's finding of a CBM patent erroneous in this matter. Based on the Federal Circuit's decision, it will be more difficult for infringers to institute a CBM review. Thank you for joining me. Stay tuned to bskb.com for more upcoming videos on interesting cases and other commentary on intellectual property.